today. My name is Olebogeng Mokhomotsi, and thank you again for joining us in today's session. Just a quick announcement. I don't know if you are aware, but I presume that you may not be. Our sessions will now run every second Thursday of every month. As you may be aware, the South African Bar Association hosts a speaker on a bi-weekly basis to deal with a legal topic that is intended to assist any legal practitioner or any other interested party, both locally and internationally, with training and development. And this ties in beautifully with our core values as an organization. Some housekeeping before we commence. An appeal to all participants to ensure that your microphones are muted and your videos are switched off during the address. Should you have a question, simply just raise your hand using the icon provided on the Teams platform, and you will be given an opportunity. Lastly, a Q&A session will commence at the end of the address. Please reserve your questions for such a stage. And our biggest request is that please ensure that your questions are aligned to the topic at hand today. Without further ado, it is my pleasure to introduce our esteemed speaker this afternoon, Mr. Mangaliso Mthembu, who is a practicing attorney at Ncube Inc. Attorneys, which is a mid-sized law firm with head offices in Johannesburg and regional offices in Tshwane and Mbombela. Mr. Mthembu has more than 13 years of legal experience, starting his career at Transnet Freight Rail, where he was exposed to administrative law, government procurement, commercial law, and intellectual property. He has gained invaluable experience in the practice of music rights management, as he was the head of stakeholder relations and international and domestic licensing at the South African Music Rights Organization, commonly known as SAMRO. And he was responsible for the following: the negotiating and drafting of bilateral agreements with foreign societies and advising on digital/online music licensing agreements with digital service providers. After leaving SAMRO, he returned to practice with a focus on music rights management, particularly the exploitation of music rights in the digital/online environment. Currently, his practice straddles administrative law, commercial litigation, and music rights management. Ladies and gentlemen, I will now hand over to Mr. Mangaliso Mthembu to take you through his presentation. Thank you.
Sorry, could you hear? Oh, sorry. I think I need to start again. My mic was off. I'd like to say thank you very much to Oxford Chambers for inviting me in to speak on a topic in which I feel very passionate about. I'd like to extend a debt of gratitude to those who invited me. I think one of the reasons why these sessions are really important for me as a practitioner is that we're always learning, and it is important for us to be on a journey of self-discovery. Secondly, this is an area of practice in which legal practitioners, whether they be attorneys, advocates, or legally trained people, are sorely needed. There is a great demand for those who possess our kinds of skills, and I believe that if more legal practitioners were to be skilled and trained and educated in copyright, music rights law, that the industry as a whole would be much better for it. Without much ado, I'd just like to start sharing my presentation. Okay. I hope we can all see.
It is clear on our side. Thank you.
Okay. As per the intro, I'll be focusing on music rights management, particularly public performance rights and mechanical rights in the context of the Copyright Act. Now, the eminent Greek philosopher says that music is a moral law. It gives a soul to the universe, wings to the mind, flight to the imagination, a charm to sadness, gaiety and life to everything. It is the essence of order and leads us all and leads to all that is good, just, and beautiful. As noted by Plato, music is a fundamental aspect of the human experience. In its melody is the kind of symmetry that binds us all. Now, law and music are integral to the human experience. And the relationship between law and music is not only metaphysical and philosophical, two are deeply intertwined. It can be argued that one cannot exist without the other. The entire business of music is premised on the recognition of music as intellectual property. In the talk, I intend to transverse a few areas of law. Particularly, I'd like to speak about the foundations of copyright law in South Africa to place the discussion in context. I'll then move on to the concept of collective management. I'll then chat a little bit about the relationship rights holders have with collective management organizations. I'll then speak about the commercial context in which music rights management occurs in reality. In the end, I'll touch on the licensing of digital service providers. In order to have a thorough understanding of where South African copyright law comes from, we need to go back to the Berne Convention of 1886, which is a fundamental cornerstone of our copyright law. South Africa is also a signatory to the trade-related aspects of intellectual property, also called TRIPS, and of course the Copyright Act of 1978, which to a large extent places the principles of the Berne Convention squarely within our law. Now, the Berne Convention of 1886 largely set out the rules for the protection of literary and artistic works. It governs international copyright and the national treatment of copyright. The convention lays out the minimum level of copyright protection by signatories. It is administered by the World Intellectual Property Organization, also called WIPO. WIPO is a self-funded agency within the United Nations with over 160 countries which are party to the Berne Convention. And this is important because it then gives a global or international standard intellectual property, and particularly music rights. The three main principles in the Berne Convention are the principle of national treatment, the principle of automatic protection, and the principle of independence. Briefly speaking, what national treatment means is that works originating in one contracting state must be given the same protection as in each of the other contracting states. The latter rights for the works which is owned by its own nationals. Essentially, it doesn't matter where works originate. Each state which is party to the Berne Convention has got a responsibility to protect that copyright. Protection must be conditional upon compliance with any formality. So the principle of automatic protection essentially means that there isn't a formality that needs to be carried out in order for copyright to be protected. As soon as intellectual property is created, it is automatically protected. Registration is not necessarily required or any other formality. Just by its mere existence, it is then protected. The principle of independence speaks about essentially in different jurisdictions, you have a length in which copyright is protected. In South Africa, it is 50 years, and it would be 50 years after the death of the author or 50 years after its publication. However, in certain jurisdictions, like the US and England, that period, the principle of independence means that even if copyright is no longer protected in your own state, it must still be respected because in the country in which it originates, it may still fall under protection. So if music that would ordinarily have, if the protection would have lapsed on the 51st year, if that copyright originated in the United States or in England, where it would still be protected, South Africa would still have a responsibility and an obligation to protect that copyright because in the territory in which it originated, it still is protected. And those are basic principles of contained in the Berne Convention. South Africa is also a signatory to the trade-related aspects of intellectual property, which is administered by the World Trade Organization, the WTO. The WTO and WIPO have a cooperation agreement in order to keep the international treatment of intellectual property robust. Both these institutions protect copyright holders internationally and grant reciprocal protections to copyright holders in signatory countries. The main copyright is a relationship between the author and their creations. It involves the following salient aspects. Registration. Firstly, copyright comes into being once a work is created. It is not necessarily required that the work be registered, but in certain instances, for instance, in trademarks, then it should be registered. But the principle is that as soon as a work is created, it is automatically protected with or without registration. Ownership, in the case of musical works, the first owner is usually the creator. While whoever commissions a sound recording or a music video is usually the owner. So the creator of the musical works, either the author deemed to be the owner. Assignment is also an important principle. Assignment, in terms of the Copyright Act, in order for one to assign one's rights, it has to be done in writing and no verbal transfer of rights or copyright is recognized. Licensing is the grant by the owner of work to license or to use the works. So ownership in that case does not transfer, but the owner would then permit a user of music to license their music, to use their music in exchange for a fee. In terms of the Copyright Act of 1978, copyright grants exclusive economic rights to the holder, and these are known as a bundle of rights or restricted acts. Now, only the owner of the works may authorize or authorize others to do what vests in each work. And each work is separate from each other and therefore assignable to third parties. The principles contained in the Copyright Act come directly from the Berne Convention. And as I said earlier on, it is the legal instrument that introduces the principles of the Berne Convention into the South African legal system and makes it enforceable. Now, earlier on, I spoke about a bundle of rights. In the context of the Copyright Act, and particularly in relation to musical works, it is said that, and I'm quoting directly from the Act, nature of copyright in literary or musical works. Copyright is a literary or musical work vests the exclusive right to do or to authorize the doing of any of the following acts in the Republic. Firstly, the reproducing of the work in any manner or form, publishing the work in its hitherto, if it has not been published, performing the work in public, broadcasting the work, causing the work to be transmitted in a diffusion service, making an adaptation of the work, and doing in relation to an adaptation of the work any aspects which relates to the paragraphs above. For for this conversation or this discussion, I'd like us to focus on performing of the work in public, as well as causing the work to be transmitted in a diffusion service. Now, diffusion service is defined in the Act, but essentially it's any kind of technological distribution or disseminating of the work, whether it be in online platforms or in broadcast using, electronic cables and the such, but it essentially how music can be transported from one point to another using electronic means. Now, the Act was written in 1978 and does need some adaptation, as we can imagine, but for present purposes, it is still able to protect copyright even in the digital context. In order to understand how rights holders are able to exercise their rights, it's important to be introduced to the concept of collective management. Now, collective management is a system where owners of their rights authorize collective management organizations to manage rights on their behalf. CMOs, as collective management organizations, are known as act as intermediaries between rights holders and music users. This is important in a practical context because you can imagine that if a composer creates work, that work ends up literally all over the planet on different radio stations, different digital platforms, different broadcasting, on film, on TV, in a plethora of rotations. And that's why rights holders, whether they be authors, composers, or publishers, rely on collective management organizations to royalties on their behalf and to administer their rights. It therefore follows that to do so. Usually that mandate is through the signing of a deed of assignment, in which that deed of assignment, the creator would then assign their rights to the collective management organization to then administer on their behalf. In the context of music rights administration, each right is severable and can be administered individually or jointly. Now, the right holder is at the liberty to choose which CMO or which entity they assign their rights in order to collect royalties or any revenue. Now, commercial context of musical rights in the fore of your mind is that a single work, as I said, encompasses a bundle of rights, and each of them is distinct and severable. The rights that I'll be focusing on specifically are the public performance rights, and to it's also important to note that I'm focusing largely on the rights of the author and the author, composer, and publisher. Just to try and differentiate the different rights that are speaking about as in a bundle of rights, in that you have the performance right, a mechanical right, as well as what is commonly called the master right or the right in the recording. Just to give you a practical example of that, there's a famous song by Whitney Houston, I Will Always Love You. Now, most of us are familiar with the version sang by Whitney Houston. That is the recorded version. And Whitney Houston is the performer. However, the composer of that song is Dolly Parton. And Dolly Parton, as the composer, is entitled to royalties anytime her composition is played to the public. And that is the royalties in which we are speaking about. Whitney Houston would be entitled to collecting royalties as the performer of the song, and that's a different conversation. The owner of the copyright of the musical recording may be the record company. I think in this instance, it may be Universal Music, but that is a different role. Now, with a focus on the public performance as well as the mechanical rights, it's important to note that permission to publicly perform a musical right must be obtained from the copyright holder or the collective rights organization that has been assigned that right. Now, the most common form of public performance or exploitation of music would be broadcast. In this context, we're either speaking about radio or TV. Live performances, if you would go to a live concert and musical works are performed there, the composers are due a royalty. In cinema, whenever we attend, there's usually music, whether it's right at the beginning or part of the cinematography. The composers of those works are entitled to compensation. There is also what is called general, and general would be whenever music is in stores, nightclubs, anywhere where music is played to the public, even community halls. Any of these users of music need to have a license. I'm also going to chat a little bit about international and digital platforms. These are the likes of Spotify, YouTube, Facebook, Netflix, Amazon, Disney, etc., which in the modern context, many of us consume music. Now, all of these exploitation types, and there is a license fee, and that license fee must eventually be paid or distributed to the rights holders. Now, earlier on, I spoke about performing rights, mechanical rights. And what's happened is that each of these rights are individual. Them have a collecting management organization that collects for each of those rights. Just on a side note, in 2010, the South African government launched the Farlam Commission in to various allegations of impropriety in the copyright sector, as well as in the collection of royalties. The Judge Farlam was requested to review and assess the concerns and allegations that the collecting model in the country at the time was deeply flawed. Now, the CRC was accountable to the Minister of Trade and Industry, and he was instructed to advise and make certain recommendations. Those recommendations is that the amended only to allow one collecting society to collect per set of rights. Now, that amendment to the copyright never took place. However, subsequent to the Farlam Commission on Intellectual Property, collecting management organizations are expected to register with trade and industry in order for them to be fully compliant. And as a result, in each sector or particular right, you tend to have one collecting society which is collecting for that right, largely due to the recommendation. Now, in the context of public performing rights, SAMRO, the South African Music Rights Organization, has the exclusive right to administer public performance rights on behalf of authors, composers, and publishers. As discussed earlier on, rights holders would conclude a deed of assignment, and that assignment, they would assign their public performance rights to SAMRO. SAMRO is then granted the right to license the use of the rights holder's repertoire, collect royalties pursuant to that license agreement, and then distribute those royalties to the rights holders. Now, mechanical rights are those rights that are generated anytime a copy of a musical work is made. Just by way of an example, anytime a CD or a cassette was copied, a mechanical right would be generated. So the act of copying a CD or copying a cassette would create a mechanical right. Now, in the digital age in which we are in, CDs and cassettes and formal, those forms are not as common. However, the mechanical right has found expression in a different way, in that anytime musical works are downloaded onto your machine, it's deemed that a copy is made. That copy is made and exists on whatever device you're accessing the music, and it will exist for a short period of time in order for you to allow you to enjoy that musical work. So it's deemed that a master copy exists in a distant computer server somewhere, and that when you as a member of the public copy that music onto your device, there is a copy is then made. So apologies, my screen just changed a bit. I want to go back to the slide. Okay, I'm back. Now, the system of collecting management organizations is one that goes back probably from the early 1900s in the UK, as well as in Europe generally. In South Africa, SAMRO was started in 1961, and soon after that, you had other collecting societies which were then established. Now, it's important to understand that for the longest time, these entities have acted as de facto monopolies, in that there's only one collecting society per each right. Now, inherently, that's not a negative thing. Quite to the contrary, by allowing rights holders to pool their rights together into these large organizations like SAMRO and CAPASO, it increases their bargaining power and allows them to negotiate better terms and licenses with license holders. However, in the last probably 10 to 20 years, there's been a change in how collective management organizations and rights holders relate to each other. Firstly, members are permitted to join more than one collective management organization that exists to administer the same right. Where that becomes interesting is that, for instance, in the South African context, a rights holder could grant SAMRO the right to collect their musical royalties in South Africa, but then join another society or collecting management society or organization to collect their rights in different parts of the country or in different parts of the world. So one rights holder could different collecting management organizations collecting in different territories. What's also happened in the context of the digital environment is that previously collecting societies would have as I said, monopoly on the collecting of and licensing of music. However, with large multinational organizations, it is now possible, for instance, for rights holders to engage with other agencies or collecting societies outside of their home territory. What is also possible, for instance, is for South African rights holders to permit collecting societies outside the country to collect royalties that are generated within the country. Now, this competition is really important in that it allows for rights holders to be able to exercise their rights in ways previously it allows for freedom of association and freedom of contract. Now, there are a number of factors that a rights holder would have to consider when choosing a collecting management organization or a CMO to collect on their behalf, and a lot of these are interwoven. The rights holder, for instance, may choose to exercise their rights based on the level of service they receive from the collecting management organization, that level of efficiency, as well as the costs of the administration. License holders can also have a look at the different licensing techniques or different licensing methodologies of the different collecting management organizations. So there's two main licensing methodologies, a blanket license as well as a claims-based license. So in the context of a blanket license, a CMO would grant a digital service provider, like a Spotify or Facebook, a blanket license to use its repertoire for a predetermined fee, a flat fee or a percentage based on some commercial terms such as turnover, subscription, or advertising. But what's important is that you have blanket licensing and then you have a fixed or predetermined fee. The other model is to use a claims-based model, where instead of where collecting management organizations would have to accept usage reports from digital service providers, analyze those usage reports, and then generate claims based on that usage. Now, in the context of a blanket license, the larger a society with a larger repertoire would be in a better negotiating position to negotiate more favorable commercial terms with digital services providers. It simply just means the larger the asset, the bigger your negotiating power. And the converse is also true. A CMO may have not the converse, but it can also be possible that a CMO may have a relatively small repertoire, but have a commercially valuable repertoire. And this may also affect the bargaining power, which is something that a rights holder would have to consider. Now, in the context of a claims-based process, CMOs with great administrative capacity would be much better placed to analyze the usage reports. Now, just by way of example, Spotify, which is the largest digital streaming service, has close to 1 billion streams per month, and they operate in more than 42 countries. And in those 42 countries, you have different subscription models. So free module where revenue is generated largely through advertising. Then you have a premium model where the user would pay more. You have a duo, families, or student, and different models based on the country in which they operate. Essentially, this means that a CMO will need to process about 200 reports on 1 billion streams every month, which begs the question that a CMO would need to have a large and sophisticated administrative and technological capacity in order to process these kind of streams in order to implement a claims-based model. Now, the factors I've raised are just some of the factors that a rights holder would have to consider when they choose which collecting management society will administer their rights. Is that it? Okay. 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 Yes, thank you. That was the presentation. I'm ready to answer any questions based on that.
Thank you so much, Mangaliso. It seems like we have 2 questions on the platform. I will start off with Laura's question, and her question is, where do South African artists register their music rights? Is it SAMRO or CICP?
Okay. Well, it would first start off with which collecting society is representing them and which rights we're speaking about. So the short answer is South African musicians or rights holders would have to register with SAMRO. So ideally, even before one starts, publishing your music or not publishing or broadcasting your music, making it available, you'd want to sign up with a collecting management organizations like SAMRO in order to collect all of your royalties. So you'd sign up with the SAMRO, become a SAMRO member, and then notify them of your works. In that notification, you'd have to put who the artist is, who the composer is, and if you have a publisher and the share of that copyright. Then an organization like SAMRO would then be in a position to collect royalties on your behalf wherever they may they may be available. So as I said earlier on, if you're an artist, you sign up with SAMRO, and if your song plays on the radio, SAMRO would have to pay you. If your song is playing on Spotify, Samro has got a licensing agreement with Spotify, and those royalties would have to come back to you. If your song is played on MTV Base, Samro on the broadcast side has an agreement with MultiChoice and the SABC, and they'd have to collect. So the short answer is Samro is the first port of call, but once you are more experienced and you have a repertoire that requires you to pay closer attention, then you can decide as to who should collect. But then I'd also suggest that South African rights holders must also be a member of CAPASO, because CAPASO is what collects on mechanical royalties. So a musician or rights holder would have to sign up with CAPASO and SAMRO to ensure that they are collecting on royalties, so all of their royalties.
All right, thank you for that. Another question. So why do South African artists generally die poor and their royalties are being paid by the SABC in billions of rands? I mean, this is something we've all really wondered over the years. Most of our South African artists do die poor. Why is that the case?
There's a number of reasons for that. And I think one of the main reasons really just goes back to education and goes back to understanding your rights, because a lot of these rights and royalties are quite complicated in terms of who should be collecting your royalties, how best to collect your royalties, and then also what to do with it. So a lot of it is that there's a big education deficit within South African rights holders and just generally. And a lot of that comes from bad advice. So a lot of, I'll call them artists, they seek advice from their managers, and their managers happen to be their friends or people they grew up with or people they are close to. They are not necessarily people that are skilled and understand the complexities of this. So I think a lot of it boils down to education. Also, it also was important to understand that the size of the industry. So I mean, someone said that they're being paid out billions of rand, for instance. You need to put that in context. So, for instance, in the previous financial year, SAMRO collected 500 million rand, or about 520 million rand, for all South African rights holders, and that had to be distributed. So 500 million rand is a lot of money to you and I, but if you need to distribute that to 60,000 members, and only the top maybe 200-300 are making decent revenue, then you can see that actually 500 million rand isn't a lot of money. And rights holders and musicians, your biggest form of income is not actually your royalties, it's your live shows. Live shows will always pay more than royalties. However, royalties, licensing, and publishing, that's a much longer income stream. So for instance, one of my clients, for instance, made hits in the 1980s, and he's still getting paid for the publishing side and the public performance because his music is still being played on radio and is still being used in film. But it's nothing compared to what he was getting at the height of his fame, when you're making more money from shows and that kind of thing. So I think the short answer is a lot of rights holders just uneducated and highs up in a precarious situation.
That makes absolute sense. Okay, we have another question from the platform. It's from Ford AJ. Please explain the difference and roles between SAMRO and SAMPRA.
Yeah, not a problem. So as I said earlier on, you've got different rights and you have different organizations collecting on those rights. So SAMRO is the South African Music Rights Organization. They collect on behalf of composers, authors, and music publishers. So the right in which they are concerned with is the right that vests in the composition of the music. Now, SAMPRA is the South African Music Public, I just forgot what it stands for, but the South African Public Performance Rights Organization. So they collect on behalf of performers. So as in the example I said before, with the Dolly Parton and Whitney Houston song, SAMPRA would collect on behalf of Whitney Houston. SAMRO would collect on behalf of Dolly Parton. Now, if you are a user of music, you would have to have a license for both the composition and the performance. So it's distinct rights. that all vest in the same musical works. But Samro, composer, Sampra, the performer. So that's the main difference.
Okay, that's clear enough. Thank you for that. Another question. We've got quite a few questions. Again,
Okay.
it's from Ford AJ. It says, are artists required to register with Samro if they market their music via iTunes?
Look, firstly, there's no requirement to register with any collective organization. It's just in your interest in order to collect royalties. So when you register with iTunes, for instance, what you'd call is that you are uploading your music on iTunes, right? And when you upload the music, what you're uploading is the master right or the recording. So iTunes would have to pay you every time there is a stream for the recording. But also, there is also the performing to the public, which is the public performance right. Now, that is not collected by iTunes or Google, or is not paid by iTunes or Google. That's paid by a collecting society. Because a collecting society would say, we are not interested in the master right. We understand that you are paying the master right to the person that uploaded the recording. We are here to collect for the composer. Now, it may well be that it's the same person, or it may be different persons. So even if they upload their music themselves, they are independent. If they do not sign up with a collective management organization like Samro and Capasso, they are literally leaving money on the table because there are royalties which are due for the composition and nobody to collect it. So it would be in their interest to sign up with the Samro or Capasso. But it's important to say there are many other institutions and collecting societies that do this. It's just that those are the big ones in the country. And it would be remiss of me not to put them in the center of the conversation.
Noted. Thank you for that. Another question. I mean, we are all aware of the music industry being plagued by pirating and copying of music and DVDs, etc. Where does the POPIA Act fit in this whole equation? How does it feature into all of this, the piracy and the copying of DVDs and CDs, etc.?
I think that's an interesting question. I think I just need to understand the context of it better. But I'll give it a step. With the issue of piracy, um, piracy really speaks about making a copy or playing the music to the public without permission from the copyright holder. So, and it's become it's still a big issue, but it's become a little less prevalent in the digital space where most people are not accessing their music legally. So you'd either access your music on YouTube with a premium subscription where you pay X amount of money, 90 Rand, and you are now accessing your music legally. Alternatively, you access the free platform, but you're bombarded with ads. So every time those ads are then played, there is revenue that's generated, and that revenue goes to the rights holder. So they always say if you're not paying for the product, you are the product. So in terms of the copyright, that's where it fit in. I think in terms of Poppy, look, I haven't really thought about it much, but I think in the context of Samro, what's really information of the rights holders themselves in order for them to be able to pay royalties. So, I mean, that have their names, that have their addresses, they would have their banking details, and they'd have person as well. Nations like Samro need to be very careful in terms of their compliance with Poppy, but also because there's a lot of interaction between the different societies. You can imagine, I'll go back to the same example. Whitney Houston's song is played on Metro FM, Sunday afternoon. Those royalties need to make their way to the United States, where she is represented by BMI. So there's an exchange of information there. So there are certain information covenants that the two organizations need to ensure are in place. So in terms of the protection of personal information, part of what we used to do when we were updating our bilateral agreements was to ensure that the personal information of South African rights holders, once we transmit it internationally, is still protected. I've tried to answer. I'm not sure if I did.
Thank you. Thank you for that. I'm satisfied with that. Before I get to the hand that's been up, let me just quickly read this comment from Dennis, or it's a question. He says, kindly provide your source for the 500 million royalty distribution. The only amount availed was in the 2020-2021 financial year.
Yeah. So in the previous financial statements, if you go to SAMRO website, and then they'll give you the financial statement. So they collected about 500 odd million rand SAMRO, but there are other collecting societies as well. So that's SAMRO. But if you also go to Capaso should have the financial statements as well. I think they collected about 200 million rand last year. Then you have SAMPRA as well, who would have collected for the performance. So the information is really publicly available. You go to the different entities, they would post their financial statements, and then you'd be that's where I got the data. I also worked there for a while, so I was part of compiling some of this information. But generally speaking, it is publicly available, and it's important that it's publicly available because these are institutions that essentially are administering funds on behalf of others. So it's actually in their interest for them to be as transparent as possible, and that's a struggle that they are constantly involved in, how to be more transparent, but also commercially viable at the same time. So yeah.
I have to agree. Thank you for that. Advocate Romeo, I see your hand is up. You may unmute yourself and ask your question.
Thank you. Thank you. Good afternoon, Mangaliso. Thank you for such a wonderful presentation. I just have a follow-up question in terms of what you were just discussing earlier, relating to the rights of the artist. I just want to check with you, if a song of an artist is being played at a party, and it's not a performance, you're just playing it. Let's say it's a song by Michael Jackson, and people are dancing, to that song, and then it ends there. How do you deal with the payment and the protection of rights in such an atmosphere? Because that frequently happens, and from what I'm hearing from you, there might be consequences flowing from that. Thank you very much.
Well, yeah. Well, I think it's the answer is quite practical. So, for instance, if you are playing in a personal context, it's not considered performing to the public in terms of the case law, because that is a private context. So it's a private party. The hope is that the music that you're playing, one, the CD is not a copywritten, is not what's called a pirate CD, because then that would be another problem. So we're hoping that you're accessing music legitimately. And if you're accessing the music legitimately on a YouTube or a Spotify, or you bought the CD and you're playing to your friends and family, that's not an issue. Where it becomes an issue is that if you're running a commercial establishment and you've got a restaurant, you've got a nightclub, and now you are now performing that music to the public for financial gain, then that establishment needs to have a license. So for instance, a lot of the shopping centers, for instance, they used to play a lot of music in the shopping center. I know Sandton City is one of them. You'd go in and there'd be music playing. Sandton City has got a licensing agreement with SAMRO, a blanket licensing agreement where they pay to SAMRO based on the size of their the square meterage of the shopping center. So they are compliant in that they are paying a license to the CMO, and the CMO must then distribute that license to the rights holders.
Yeah. Okay. Thank you so much. I really appreciate that. And my stream of choice is Spotify, so it's good that you were speaking about it as well. I just wanted to check with you that is it true that this music streaming online format does not pay the musicians very well in terms of their money, and as opposed to the sales of CDs in the past? I just want you to have a step on that. Thank you very much, Mangaliso.
Yeah, well, look, the short answer is yes. They don't pay very well, but the deeper answer as to why that is a lot more complicated. So if you speak to Spotify will tell you, and they just released a media statement yesterday to say that they have now paid close to $40 billion into the hands of rights holders since their inception. So they're saying that of every dollar that they receive, they pay 70 cents to rights holders. So Spotify is saying that we are doing the right thing. But when you look at how those funds are then distributed, it's very skewed in favor of the largest performance and rights holders. So I think Taylor Swift is probably one of the wealthiest, is the what's called the biggest rights earner on Spotify because of the algorithm that they use. So, and radio stations, they would pay a lot more in terms of their going rate. So the short answer is yes, but then it's also incumbent upon rights holders to then look at, in this changing world, how do you now ensure that you're not leaving money on the table and ensuring that you are receiving all of your royalties, you know? So for instance, if you are generating a lot of digital streams, you need to look at Samro and Capasso. Are they collecting for me? Are they the best person to collect for me?
Okay.
Maybe they can come to my office and I can tell them, you know what, there are other people that can collect for you. There are international societies in Europe, in the US, for instance, that can collect for you as well. So rights holders need to now understand who's best placed to collect on their behalf. But yeah, streaming is a much smaller revenue stream, but it's becoming more and more important. And there's also the different sides of the streaming. So you have the master right, which is the recording, as well as the composition. The master right is the recording will always be more than the composition side. Usually anything from 10 to 25% of the master right. So it's really about knowledge, and it's really about seeking out those professionals who can assist you in order to maximize and manage your royalties.
All right. You are one of the people that should advise Makadzi to bring it to the level of Cardi B. No, thank you very much, Mangaliso.
It seems like we have no more questions. Oh, is there? Oh, there we go. There's another one from Dennis. He says, have you had clients that utilize artificial intelligence in collecting and cleaning royalties? Interesting question.
Well, actually, I think that is an interesting question. And the space of musical royalty collection is becoming very much one of IT and the ones with the biggest, not just administrative capacity, but technological capacity to do so. So what you'd find is that you'd have institutions like SAMRO, like Capasso, I think in Switzerland it's Suiza, in the US it's PRS, and they would employ various technologies in trying to source royalties, and in order to maximize royalty collection. So AI is definitely becoming a lot more important in terms of royalty collection, but not so much in royalty collection. Where AI plays a very big role is in ensuring the popularity of music, because all you can do is collect music that's played. So AI is very important when it comes to understanding musical tastes, understanding what it is that us as consumers of music responded to. So earlier on, Advocate was speaking about using Spotify. Spotify is amazing at somehow picking an amazing song that you love. That is AI looking at your listening patterns, comparing your listening patterns with other users, and then recommending songs that are that you would enjoy. So in my experience, AI is really important in making music more popular, and once it's more popular, then the collecting societies are then able to pick up the royalties, because collection, yes, it's complicated in terms of the machines that are required, but all you're doing is matching the number of streams, dividing it amongst the different contributors, and then seeing how much money you've got to share. So on bare bones, it's simple, but the devil is in the detail.
Absolutely. I just want to make sure I have read all the questions. Let's see. We have music audit usage systems spearheaded by renowned DJ and producer Mark Stent in South Africa. I think he's still probably typing his question. Outside of that, there are no hands that are being raised. So I think we've pretty much come very close to the end of our session. I'm just going to wait for Dennis to make sure. Unless, Dennis, you want to go on the platform and, oh, there we go. All right, so it was a statement. It says, thanks for the platform. Mangaliso, I just want to take this opportunity and thank you personally for being our speaker today. We thoroughly enjoyed your informative session. And thank you to everybody that logged on and was a part of today's successful session. We look forward to seeing you guys again in about 2 weeks' time when we have where we'll be discussing a new topic with a new speaker. Thank you so much and good afternoon.
Thank you.